Start. Judging the claims of the respective parties, in this case, in the light of the principles noticed above and specific provisions in Order 18, Rule 17 and 17A. Stop. I am of the view that the court below has misdirected itself in rejecting the application and denying the petitioner of an opportunity to recall and examine the plaintiff examined earlier as PW4 with reference to a particular document to which the plaintiff was said to have been party by signing and issuing the same stop. It is by now well settled and often reiterated that the procedural law should be a guide as also handmade to render substantial justice stop unless the law itself provides some serious consequences on account of any lapse committed. The endeavor of the court should also be to ensure that all relevant and the best materials are allowed to be brought on record, which could effectively, conclusively, and finally adjudicate the dispute between the parties. Stop. The power of the court under Order 18, Rule 17 and 17A to do so and to direct recalling the re-examining of a witness who has been examined earlier to put any questions as the court may deem fit or to produce evidence not previously known and could not be produced despite due diligence cannot be seriously disputed. Stop. The question is as to whether in a given case or for that reason in the present case the request of the petitioner before the court below is in order and in accordance with law and could have been rejected and refused to be allowed in the manner it has been done by the court below. Stop. In my view, the court below, in rejecting the request and denying the opportunity to the petitioner defendant, has committed not only a grave error but has chosen to stall a relevant piece of material in evidence being brought on record, which would help the court itself to effectively decide the issue. Stop. The case of the plaintiff is that he is the owner of the property. Stop. The defendant in the written statement has categorically stated that the predecessor in interest through whom the plaintiff claims was never inducted as a tenant in the suit land and that he was a chokidar and the defendant alone is the owner and that he has been cultivating the same by hiring labor. Stop. The receipt alleged to have been passed on by the plaintiff himself could not be said to be an extraneous or irregular material in deciding the relationship of the parties. Stop.